Welcome to NACD BoardVision, where leading boardroom advisors, governance professionals, and seasoned directors discuss critical issues related to your responsibilities in the boardroom.
Hi, I'm Steve Kalan, and welcome to BoardVision. Today, I'm happy to have Brian Breheny with me. Brian's a corporate and M&A partner in the Washington office of Skadden Arps. So after a long delay, the SEC is scheduled now to consider adopting rules for the conflict minerals portion of Dodd-Frank. Brian, let's talk about what public companies and their directors should be focused on with these new rules.
There are 3 items on the agenda for the August meeting at the SEC, but the conflict mineral provision is one that has been very focused on. And the reason why is because the SEC itself admitted when the rules were proposed that when adopted, these rules would apply to a vast number of SEC reporting companies across all sorts of different industries. And as a result, Congress put this provision into the Dodd-Frank Act. And when adopted, companies that use any of the conflict minerals, and that terminology is defined within the rule itself, if they use conflict minerals from any of the Congo, the country of the Congo, or the 7 countries surrounding the Congo, in any product, it's necessary to the functionality of any product that it manufactures or contracts to manufacture, they have an obligation to provide disclosure, put together a due diligence process, and perhaps actually bring in a third-party auditor to certify the process itself.
Brian, this conflict minerals portion of Dodd-Frank is a huge deal for directors and audit committees. When does this actually go into effect?
The statute itself, Steve, when it was adopted by Congress, includes a provision that companies will need to comply with these disclosure rules covering the first full fiscal year after the law is enacted. So by the statute itself, if the rules are enacted in August by the SEC, the statute will require that public companies that have a December 31st year end, a fiscal year end, calendar year end, would have to cover 2013 when they file the 2014 SEC report.
We know directors are looking for help from audit firms on conflict minerals reporting. Is this because they want guidance in managing risk, or is this mostly due to their needs for supply chain audit skills?
Steve, it's probably a little bit of both, because as you can imagine, if you're the company, the public company already has an independent audit firm that's helping them audit their financial statements, you're going to, I suspect, want them involved as you set up this internal process, your normal disclosure controls and procedures and your involvement that you would have at your typical audit firm. The conflict mineral provision itself requires, again, if you trigger this, not every company will have to do this, but if you trigger it, you'll need to provide a report of an independent third-party auditor. Question, by the way, whether that independent third-party auditor can be the same auditor that you're using or whether there'll need to be another auditor brought in. There may be some guidance, again, that's issued when provided by the Commission when they issue these rules. And I think that companies, as part of their planning process, they should be thinking about what they're going to do internally to implement these rules, and they should also be thinking about what involvement that they're going to need from their auditors to get the reports that they'll need to comply with the rules.
You mentioned that there are 3 main matters the SEC is writing rules on right now. What are the second and third issues?
Sure. The second item, Steve, is also shaming disclosure. That's a provision that requires resource extracting companies. Those are companies that are in the commercial development of oil and gas and natural resources. Those public companies that are in that space will be required, if the rules are adopted by the SEC, to disclose publicly payments that they've made in connection with this extraction, these commercial development of these minerals, to the United States, the federal government in the U.S., or foreign governments. And again, just like in the conflict mineral space, there are a lot of open questions as to how these rules will apply to these companies. The third item relates to the Jobs Act, which, as you know, Congress adopted, put together a bunch of provisions, some related, some not, and the SEC has quite a bit of rulemaking required by the Jobs Act. The first thing that they're looking to take up is a provision that would eliminate the ban on general solicitation and advertising in Rule 506 Regulation D offerings and Rule 144A offerings. So a very specific area, but one I think that will be welcome welcomed. Probably not a provision, Steve, that's at the top of companies' minds, but it will be helpful as companies do capital raising transactions to be able to solicit, be able to talk to their investors, advertise to future investors. At the end of the day, when the transaction happens, you still need to be selling to accredited investors and to qualified institutional buyers. But so there's going to be some hoops that will have to be jumped through in order to qualify. But I think that eliminating the ban on general solicitation and advertising will be welcomed.
So, the bottom line is directors really need to stay tuned into the SEC rules on several topics now.
There are other provisions that are on the list to come up. One, by the way, very recent act that was just adopted at the beginning of August by Congress and has been sent to the President for his signature is the Iran Threat Act. I think it's the Iran Threat and Syria Human Rights Act. And that provision, there's lots of provisions in there, but one of them will require SEC reporting companies to publicly disclose interactions with the Iran government and certain other designated officials. So it's another example of Congress using the Securities Act to further some unrelated, if you will, provision. So companies that perhaps are doing business in that region will have to kind of think about those rules and think whether they're going to have to comply.
We anticipate much dialogue now on these new SEC rules. Given your background at the SEC, we'll likely want you back again to help us review what these new rules mean for directors. Thanks for joining us. I'm Steve Kalan, and this is BoardVision.